As you're probably aware, Epic Games, owner of Fortnite and the Unreal Engine, has just filed a massive antitrust lawsuit against Apple Computers over its alleged monopolistic anti-competitive practices for in-app purchases on apps delivered through Apple's App Store, and therefore all of the apps on the iOS platform. Apple maintains in its developer agreement a requirement that all in-app purchases will be done through Apple and subject to a 30% commission on every single sale. Epic intended to circumvent this by creating an alternative option within Fortnite for in-app purchases to go through Epic at a reduced price and therefore a reduced commission. Apple called this a breach of its developer agreement and removed Fortnite from the App Store. It similarly threatened to remove the Unreal Engine and all other Epic-owned properties from the App Store, despite those developer agreements not being breached by Epic Games. Epic motioned the court for a preliminary injunction and asked for a temporary restraining order pending the outcome of the preliminary injunction. They have asked the court to intervene and prevent Apple from removing Epic properties, including both Fortnite and the Unreal Engine, from the App Store. Let's talk about what happened in court and the key takeaways from the ruling on the temporary restraining order. Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, and we've got a big one to talk about today. This is the ongoing case, the antitrust case between Epic and Apple Computers. Epic, of course, is the owner of Fortnite and the Unreal Engine. Apple is Apple, owner of the iPhone and the iOS software package that exists, powering roughly half of United States mobile devices, as well as millions and millions of devices around the globe. So, in this case, we have a lot of questions, and it's a really large case. It's actually got, I think, 10 alleged violations of the Sherman Antitrust Act, and we're not going to get into all of that today because today we're just talking about Epic's motion for a temporary restraining order and a preliminary injunction against Apple, preventing Apple from removing Fortnite and the Unreal Engine from the App Store. Now, they had a hearing on this just yesterday, which was the 24th of August, and the order was written by the judge the same day, granting in part and denying in part that motion. So what does that mean? What are the key takeaways? That's what we're going to be talking about as we get into this. We're going to use the actual order from the court as our reference point, but just in case you're looking for the shortest possible route to the answer, let's say this. The court denied Epic's request for a temporary restraining order on the removal of Fortnite, but it granted Epic's request for a temporary restraining order on the removal of the Unreal Engine and any other properties owned by Epic that are not in breach. And we're going to get into the reasons why, but the biggest takeaway on this aspect of it is the court says that Epic has the ability to remedy the problem for Fortnite at any moment in time. They can simply say, they can simply remove the alternative App Store or in-app purchase option that they created. They can remove that, undo the hotfix that they patched in, and then it will be a complying property and allowed back on the App Store. Whether or not Epic will do that is entirely up to Epic Games, and I think there are reasons for or against doing that. We'll have to wait and see what they do. However, for the Unreal Engine, that is not something that's so easily remedied, as the court will explain, and we get some pretty interesting looks at how temporary injunctions work, or temporary restraining orders work, I should say, and how the court looks at these issues. So let's take a look. I've highlighted the important parts of the documents, and that will be our guide for going through it. Okay, So now before the court is Epic Games' motion for a temporary restraining order, requesting broad relief with respect to all of its products, including those managed by affiliates. This is an important distinction here that the court makes right away, and it is critical to the outcome of this case in many respects. And that is that Epic Games owns Fortnite, and a different Epic subsidiary owns the other properties. And a subsidiary entity is a separate entity for legal purposes. That's why they're created. That's the whole point. And the court mentions piercing the veil. We're not going to really get into that because that's completely hypothetical and outside the scope of this discussion. However, right now, the court is looking at Epic Games and the other branch of Epic that owns the Unreal Engine to be two separate entities, because legally they are. And so since they're two separate entities, we have different calculi going into whether or not Fortnite and the Unreal Engine deserve the same treatment. And the court's conclusion is that they do not. The court grants in part and denies in part Epic's motion for a temporary restraining order. So Epic Games is a US-based tech company that specializes in video games, including Fortnite. Fortnite's next season. I highlighted this because there's a part later where the court says it doesn't understand what's going on. I highlighted this for a very specific reason because I want to pontificate that I pretty much understand the timing that Epic has chosen for this, and I think the court might understand it or is just being dense. Fortnite's next season starts on Thursday, August 27th, 2020, and will require an update of the game to play. Epic Games International, SARL, Epic International, is a related company based in Switzerland that hosts, among others, the Unreal Engine. This is the thing. They're related but separate entities. Apple is a ubiquitous tech company that makes products ranging from hardware to software. Apple, as relevant here, maintains an app store for the iOS platform that is geared for its mobile devices, the iPhones. Apple generally takes 30% of the sale of the application or of the IAP mode within the third-party application itself. Apple's agreements with developers in the App Store guidelines do not generally permit third-party developers to circumvent the IAP system. And this is a critical part of the case. This is actually Fortnite's entire claim. They're saying that this is a violation of the Antitrust Act, that this is anti-competitive monopolistic practices, and therefore this should be undone. And if you want to get briefly into the overarching theory and a nice analog in history, you can look back to Microsoft in the 1990s, where Microsoft was selling the Windows platform, which was on something like 90% of computers at that time. And the Windows platform itself came preloaded with Microsoft products like Internet Explorer, Word, and Outlook, I believe, were some of the key products at issue there. The courts determined that Microsoft's inclusion of those and failure to include its competitors gave it an unfair competitive advantage over potential competing companies like Netscape, for example, or other competing email companies. And therefore, they required Microsoft at that time to either remove its products from the system or to ship with competing products on board, which is why so many people had both Internet Explorer and Netscape Navigator loading in when they bought a new PC. And they would typically have to pick one or the other. So that's a nice analog here. We've got Apple, which prevents any third-party installation of apps, and it similarly prevents any third parties being available for in-app purchases. Google, by contrast, does allow for third-party installation of apps, and you may be familiar with one of them. A huge one is Amazon. Amazon has an entirely separate app store that can be used on Google Android devices, which similarly would allow for different payment processing to take place. So we've got a big difference between Apple and Google on iOS and Android. Apple maintains separate developer agreements and developer program licensing agreements between Epic Games, Epic International, and 4 other affiliated entities. Apple also maintains a separate agreement, Xcode and Apple SDK agreement, regarding its developer tools, software development kits, or SDKs. And this, again, is the important part for the Unreal Engine. Not only are they separate entities, they're under entirely separate agreements, separate types of agreements. So it's not just two developer agreements. We're talking a developer agreement and then an SDK developer agreement. Those are different things for Apple. And this is all factoring into the court's determination. On Thursday, August 13th, Epic Games made the calculated decision to breach its allegedly illegal agreements with Apple by activating allegedly hidden code in Fortnite, allowing Epic Games to collect in-app purchases directly. In response, Apple removed Fortnite from the App Store, where it remains unavailable to the date of this order. Later that same day, Epic Games filed this action and began a pre-planned and blistering marketing campaign against Apple. And let's be clear on a couple of these terms. They're saying that the agreements are illegal, and what they're allegedly illegal. What they're alleging is that Apple has created unconscionable requirements in their contracts that people are not able to negotiate away. And this is going to be one of the big parts that goes against Apple's favor. Presumably, it doesn't mean Apple will lose in any sort of way. They might prevail on this, they might not. We'll have to watch. But the Apple contracts that are required to access the iOS ecosystem are contracts, what we call contracts of adhesion, which means you do not get to negotiate the contract. You are simply required to accept its terms to go ahead and participate in the existing product. Now, sometimes that weighs against a company, as the US pretends that contracts of adhesion are disfavored. Even though we actually apply adhesion contracts every single day, the court still does regard them as disfavored, and therefore they are a presumptive disadvantage for the company. Apple doesn't let you negotiate that 30% price point. And there's lots of very practical reasons why they wouldn't do that. They're not entirely nefarious. But if Epic, who's going to sell millions and millions and millions of in-app purchases through Fortnite, wanted to reduce prices for its customers or even increase profits for itself, wanted to change that commission rate from Apple, they would presumably, under just a normal contract, have the ability to go ahead and negotiate that out. Under an adhesion contract, you do not have that option. You just merely accept the terms. So that's one of the big problems here that they're going to be going after. And that kind of looks like an anti-competitive practice when not only do you take away the ability to compete, you similarly refuse the ability of someone to negotiate their own terms. Okay, so in response, Apple removed Fortnite from the App Store where it remains unavailable. And yes, the blistering marketing campaign. That was, sorry, the other thing I wanted to talk about. The fact that Epic breached its contract and the fact that it created a blistering marketing campaign in advance does not really weigh against Epic all that much. They may argue, as it was argued at the actual hearing, that they came into this with unclean hands because of the marketing campaign and all of that. But really, if the contract's terms are unconscionable, then breaching the contract is, in a way, a matter of getting to justice. And that is part of all of this. Epic is trying to leverage public pressure against Apple, and it could actually affect the court case in very interesting ways. One of them being this removal of the Unreal Engine is actually a public pressure doctrine that is going against Apple, as we'll see going forward. The following day, Apple responded sternly. It informed Epic Games that based on its breaches of the App Store guidelines and the developer program license agreement, it would be revoking all developer tools, which would preclude updates for other programs, including its Unreal Engine. All right, so that's just a factual background. Now we're into the legal standard. Preliminary injunctive relief, whether in the form of a temporary restraining order or a preliminary injunction, is an extraordinary and drastic remedy that is never awarded as of right. That means no one has a right to a temporary restraining order. That's not the purpose of it. That's not what you're asking the court to do. You're not asking the court to protect your rights here. That requires more discussion on the merits. This is about protecting the status quo. A temporary restraining order is not a preliminary adjudication on the merits, but rather a device for preserving the status quo and preventing the irreparable loss of rights before judgment. So it's important to know, because we're going to get into things like showing the probability of success and all of that, that none of this actually will have an impact on the underlying case. The underlying case will be decided on the merits. This is an emergency measure to prevent irreparable losses or harm from occurring to either company or even to third parties based on the actions here. And that's what Epic is arguing, is that by Apple removing Fortnite and the Unreal Engine from the App Store, they will cause irreparable damage not only to Epic Games and their reputation, but also to other people who use the products. Fortnite players would be one argument, and then, of course, developers who use the Unreal Engine SDK for their products would be irreparably harmed as well. So in order to obtain such relief, plaintiffs must establish 4 factors, and this is the winter test for preliminary injunctions. 1, that they are likely to succeed on the merits. Now, this is a high bar, and if you can show that, as well as just satisfying the other 3, if you can make a strong showing that you're likely to succeed on the merits, then a preliminary injunction is basically going to be granted. Because it says, oh yeah, outside of something we just can't foresee, they're going to succeed. Now, Epic failed to do that here, but it's not fatal, as we'll discuss. 2, that they are likely to suffer irreparable harm in the absence of preliminary relief. And this is another very critically important factor. 3, the balance of equities tips in their favor. That means that the equitable outcome, where everybody is made whole, tips in favor of the plaintiff in this case, or Epic. And again, we'll talk about these in detail. And 4, an injunction is in the public interest. So here we have the court's analysis, and we're going to go through each of those 4 points and take the main takeaways. And what you're going to find on most of these points is that there's an opposite approach for Epic Games and Fortnite and Epic International and the Unreal Engine. And that, I think, is prudent here, and it's entirely related to Epic's ability to undo any damage by merely removing the patch that was put into Fortnite. All right. So for the likelihood of success on the merits, the court cannot conclude that Epic has met the high burden of demonstrating a likelihood of success on the merits, especially in the antitrust context, because it's really hard to do in the trust environment that we've built over the past couple decades. Even since the Microsoft decision, the trust calculus has changed pretty dramatically to be more favorable to companies that would be more likely to be trusts back in the 80s and 90s than they are today. So they're favoring larger, aggregated, and anti-competitive companies as a matter of law today, which makes this a little bit harder and makes it a very fact-specific question. So saying they can't show a likelihood of success. However, the court also concludes that serious questions do exist. And then it goes on to talk about this case is being brought into another existing antitrust case against Apple, which has been going on for a year now. And this is what we call a comparable case. And some of the facts in each of these cases track along together. And so both of these cases will have an impact on the outcome of these 2 companies. So irreparable harm. So obviously, the court laid out pretty clearly that they have not established that there's a likelihood of success on the merits. That does not mean that they're not likely to succeed. It's likelihood of success on the merits is a term of art in regards to temporary restraining orders. It's not actually a commentary on whether or not the underlying parties will succeed. Now, if you do demonstrate a likelihood of success on the merits, you're on a pretty good track. But not being able to demonstrate it doesn't have any impact on the underlying case. Epic will still have the full ability to make its arguments, and Apple will still have the full ability to counter all of those arguments as best they see fit, and then the court will determine where the law falls on this issue. Irreparable harm. The issue of irreparable harm focuses on the harm caused by not maintaining the status quo. And the summary here is that by Epic Games changing or hotfixing in an alternative payment center, they change the status quo, and that is not acceptable for a preliminary injunction. However, by Apple taking a retaliatory approach to another company, Epic International, and the Unreal Engine, that was not an Epic-induced change of the status quo, but rather an Apple one, since that developer agreement was not breached and is in fact separate from the other. So that's what the court's going to analyze here. And this is going to be, this is, again, that critical difference between Epic Games and Epic International and the different types of agreements. So here the court's evaluation is guided by the general notion that self-inflicted wounds are not irreparable injury. Further, courts generally decline to find irreparable harm that, quote, results from the express terms of the contract. So even though those terms may be unconscionable and may be unlawful, if you decide to breach those terms to make some sort of point, you are causing the injury. What the court would have you do is explain in just a minute. The court finds that with respect to Epic Games' motion as to its games, including FORTNITE, Epic Games has not yet demonstrated irreparable harm because, quote, the sensible way to proceed is for Epic to comply with the agreements and guidelines and continue to operate while it builds a record. If they're under an illegal or unconscionable agreement, they will remain under that agreement. They have made money under the agreement, they've been successful, and they haven't even alleged that the agreement is causing them specific and particular financial harm, just that the terms are anti-competitive and should be changed. So any injury that Epic Games incurs by following a different course is of its own choosing. So they have chosen to breach their agreement, and any harm that comes from that breach is their own choosing. If they were to prevail on the antitrust claims, they would potentially have a massive financial windfall coming to them anyway for the existing antitrust practice that's been going on by Apple. So the court here is saying that they're not getting a new harm or new injury except one of their own making. And any existing injury that existed prior to that hotfix that Epic patched in was something that would already be resolved by the end of this court case. If Epic were to prevail, they would be entitled to try and prove out damages based on sales that occurred. And they would be able to then go after Apple for that amount. So that Epic Games would prefer not to litigate in that context does not mean that irreparable harm exists. You can't create irreparable harm for yourself. It has to be an action from the other party. So by contrast, Epic Games has made a preliminary showing of irreparable harm as to Apple's actions related to the revocation of the developer tools, the SDKs. The relevant agreement, the Apple Xcode and Apple SDK agreement, is a fully integrated document that explicitly walls off the developer program license agreement. So they're laying out here that Apple is acting in a retaliatory manner against another entity and another program that is not related to FORTNITE. And in fact, it's specifically not related to FORTNITE under the terms of the agreement itself. So Epic International appears to have separate developer program license agreements with Apple, and those agreements have not been breached. Apple is also hard-pressed to dispute that even if Epic Games succeeded on the merits, it could be too late to save all the projects by third-party developers relying on the engine that were shelved while support was unavailable. Let me break down this sentence because it reads a little weird, but Epic has alleged that if the Unreal Engine is removed and they go on to succeed in their overall claims against Apple, that there will still be irreparable damage done to Epic and to third-party developers who are using the Unreal Engine. Because there's a gap of time that will occur between the onset of the case and the resolution of the case, that gap in this type of environment would cause a lot of damage to other people. And Apple has failed to properly dispute that. They have failed to show that irreparable harm will not occur if they remove the Unreal Engine. So this is where Apple has failed and where Epic has succeeded. Now, on the balance of equities, it is not clear why now became so urgent. Because this has existed for a while, and the court is saying, why now? Well, I'll tell you why now. Because in 2 days, on the 27th of August, the next FORTNITE season will start, and right now, millions of iOS users will not be able to access FORTNITE once that occurs, because they will not get a proper update of the application that they will need to start the next season. And this is a huge problem for those players who desire to play a very, very popular game. So Epic, in my opinion, has strategically timed this to coincide with the update of the new season and put pressure onto Apple to change the terms or to face public backlash for their actions. That's a gamble. Whether or not it will succeed really depends. But the fact that they did this, what was it, 14 days, 2 weeks to the day before their new season took off, to me says that that's why now has become so urgent, that they were ready to do this at season change. If the plaintiffs there in the Cameron case, I mentioned a parallel tracking case, if the plaintiffs in Cameron or in this case prevail, monetary damages will be available and injunctive relief requiring a change in practice will likely be required. So that's what I was mentioning earlier, that if they win on the antitrust aspects, there will be monetary damages, and also Apple will be forced to operate in a different way that would be more favorable to the competitive nature that Epic is looking for. So thus, in focusing on the status quo, the court observed that Epic Games strategically chose to breach its agreements with Apple, which changed the status quo. No equities have been identified, suggesting that the court should impose a new status quo in favor of Epic Games. This is, again, related to Fortnite. By contrast, with respect to the Unreal Engine and the developer tools, the court finds the opposite result. In this regard, the contracts related to those applications were not breached. So we have the scale of equities tipping in favor of Apple on the first part, on the Fortnite release, and then in favor of Epic on the Unreal release, because they didn't actually breach anything. The status quo, the maintenance of the contracts was not changed for the Unreal Engine. It was changed for Fortnite. So Apple has chosen to act severely, and by doing so has impacted non-parties and a third-party developer ecosystem. In this regard, the equities do weigh against Apple. And now we're on to the public interest section, and then that'll be wrapping us up. I know this is a long video, but this is a big and complicated issue, and I'm trying to distill it down as quick as possible. With respect to the gaming requests, the court recognizes that Fortnite players are passionate supporters of the game and eagerly anticipate its return to the iOS platform. A bunch of Fortnite people sent stuff posted all over the internet that, they want it to be back on iOS. During these coronavirus pandemic times, virtual escapes may assist in connecting people and providing a space that is otherwise unavailable. This was one of Epic's big arguments. We're in quarantine, baby. We need to go ahead and have people talking to each other and interacting with each other in the ways that they can because other social avenues are cut off. However, this showing is not sufficient to conclude that these considerations outweigh the general public interest in requiring private parties to adhere to their contractual agreements or in resolving business disputes through normal, albeit expedited, proceedings. So they're saying, look, this is important, right? Mingling, socializing during a pandemic, very important. We know Fortnite players love it. However, you are breaching a contract, and the public interest is in you persisting in that contract. And had you not breached that contract, this is the unspoken part, had Epic not breached, then none of the COVID stuff would be an impact at all. They'd already be enjoying Fortnite on their iOS devices just as they were. We would assume that the same track would be going forward as far as the status quo. With respect to the Unreal Engine and the developer tools, the calculus, again, changes. The record shows potential significant damage to both the Unreal Engine platform itself and to the gaming industry generally, including both third-party developers and gamers. Not only has the underlying agreement not been breached, so again, outside of Apple's meddling in this part of the case, everybody would be enjoying everything as normal. Even if Fortnite's taken off, all other development of everything else is not impacted. But the economy is in dire need of increasing avenues for creativity and innovation, not eliminating them. Epic Games and Apple are at liberty to litigate against each other, but their dispute should not create havoc to bystanders. Certainly during the period of a temporary restraining order, the status quo in this regard should be maintained. Temporary restraining orders are temporary, and that means that the court can step in and smooth things out for everybody except for Apple and Epic Games. And that's really what they need to do here. So weighing of the factors, the winter factors weigh against granting a temporary restraining order based on Epic Games' request as to Fortnite, and of course in favor of granting a temporary restraining order based on as to the Unreal Engine and other affected developer tools. And now we can move on to the last part of this case, which I didn't highlight because it's already bullet pointed out. We have the timeline for the underlying preliminary injunction. So the temporary restraining order will be good potentially until the issuance or denial of a preliminary injunction, at which case the order there would take over. So we've got the motion needs to be filed on or before September 4th, 2020. The response to the motion on or before September 15th of 2020. And the reply in support of the motion on or before September 18th of 2020, which is a pretty aggressive briefing schedule. And hearing on the motion will be on September 28th, 2020. Via the Zoom platform. Now, this all occurred because Apple threatened to remove the Unreal Engine by the 28th of August. So we would have at a minimum 1 month of time where significant changes and damages could occur to that Unreal Engine that would then have ripple effects throughout the entire country and really throughout developers across the world. So that's what the court is preventing with this temporary restraining order. The preliminary injunction will determine whether or not this restriction persists through the case itself. And it'll be pretty interesting to see what briefing occurs and what the courts decide to do as a result of that. One thing you can count on is that this channel will be covering those motion filings, and we will be talking about how this case will move forward. And I will also try and bring in some guests to discuss both sides of this case as it moves as well. So if you're looking for that, go ahead and hit that like button, that subscribe button, share this video around, let people know about the details of what's been going on, try and get as accurate of information as possible. This is a big case, and it could really go on for years, but we'll see what happens. All right, guys, thanks for tuning in. I hope you found this informative and educational. If you did, hit subscribe, hit that bell notification, and come on back. Talk to you soon. Peace. Peace.